update on the UMG situation.
Rick Beato, now it's personal. You are legally entitled to keep the revenue that is earned on your videos. You absolutely should not let a company come in and take that revenue from you. I'm gonna show you the fair use language that you can file if you ever get one of these claims. Straw and camel's back, you get my drift. Rick says, now it's personal. Rick Beato came out with a follow-up video entitled, Now It's Personal, the UMG drama continues. This is what I do, and it's not just all the clients that we represent that are having this exact same issue of major record labels are filing these claims in extremely high volume to collect the monetization on YouTube creator videos. So meaning YouTube creator videos of educators like Rick Beato, reaction channels, and also channels that do like newsy types of things about the music business. And the reason why that matters is that they're not allowed to do that. And so essentially they are weaponizing the existing copyright system that is on YouTube. Now, my job with my channel is to empower you guys to know how to defend yourselves. So at the end of this, I'm going to show you the fair use language that you can file if you ever get one of these claims. So stay tuned for that. Be sure to subscribe right now and let's jump into it.
Everybody, I thought I'd come on and give you a quick update on the UMG content ID situation that I've been going through where I'm getting these ridiculous amounts of claims all the time. But before we begin, I'd like to thank all the YouTubers that made videos in support of my situation with UMG. It means so much to me. I really appreciate it. I made a video a couple weeks ago about the many claims that I've been getting from UMG just out of blue, really in the last 2.5 months or so. They just come in every day. As you can see from this is just yesterday. You can see they just came in right in a row. I probably had 25 yesterday. They're going after old videos. They're going after shorts, all these kind of things. And then I saw something interesting. I saw a claim for a video that I already fought, which was the video of the most complex pop song ever. It was about the Sergio Mendes track, Never Gonna Let You Go. Here are the two emails. The first is from June 22nd, 2021, when I got the original claim for Never Gonna Let You Go. And here's the one I got on September 3rd for the same song. You can see it's UMG on both of them. What had happened originally is that I fought the claim and I won it. And here's what happens. You claim fair use, and they have a 30-day period in which to respond. And they never responded until yesterday.
And for a lot of content creators out there, step one of you get a claim and then you get to respond, and there's no impact on your channel. It's when you progress to stage 2 that there's now a huge risk. And as a lot of YouTube content creators have described it, it is a terrifying process to go through. But one thing that we know for Rick is that he has not been fighting these claims at all until recently, like in the last year. And this matters because what major record labels and other similar type of companies are doing is that they're filing these claims for the monetization. Because it's kind of like a bully tactic where they go, if you don't fight our claim so we get to collect the revenue earned on your videos, well, we're not going to escalate it to that scary step 2. And so what's happening is that as these content creators are kind of wising up and they go, the law is that I can use your stuff so long as I qualify for fair use. We're going to talk about what that is and how you qualify. But it's not easy to run a YouTube channel. And if you are legally entitled to keep the revenue that is earned on your videos, you absolutely should not let a company come in and take that revenue from you. But in this situation, Rick's talking about how there was already a claim. The time lapsed, and as I'm sure he's going to discuss, the claimants cannot refile the same claim.
And they claimed the video again. And I was like, I won that claim because they never responded in 2021 in that 30-day period. And here's the language. After a YouTube Content ID claim expires, the claimant generally cannot reclaim the same video for the same content. The expiration of a claim after a 30-day period without a response from the claimant is considered a resolution of that specific dispute. According to YouTube's terms of service and help documentation, when a user disputes a Content ID claim, they have a 30-day window to review and dispute and take action. If they fail to do it within this time frame, the claim is automatically released. This process is designed to provide a clear and timely resolution for creators, and that's what happened. I claimed fair use on that one video. It's one of the few that I had ever done back in 2021. They didn't respond.
Now, this is just YouTube's policy. I'll make the comparison to like the law. This happens in the law as well. If you like file a lawsuit and you lose and you had your shot, you don't get to go and do the whole thing again. So that procedure is reflected in the YouTube procedure as well.
There could be a redetection, technically, that YouTube Content ID system could automatically flag the same content, again in a different upload, which did not happen. Or manual claims. It says, while less common for Content ID, a copyright owner could still manually file a takedown notice if they believe their copyright is being infringed, even after a Content ID claim is expired. They go on to say, in essence, the expiration of a Content ID claim following a dispute is intended to be the final word on the specific claim. The creator should not have to repeatedly address the same claim from the same rights holder on the same video if the claimant has already failed to act within the stipulated time frame. If a claimant attempts to reclaim the video after identical claim has expired, the creator can dispute it again, referencing the previous resolution.
Okay, so is that YouTube acknowledging that this issue exists? Because it says, that last line, if a claimant attempts to reclaim a video after an identical claim has expired, the creator can dispute it again, referencing the previous resolution. So they're basically like, we'll make it easier for you because you'll say, hey, I already dealt with this. Fine, but why is the same claimant able to file the exact same claim on the exact same video if it's against your policy? Now, they have the exclusions. They're like, if you upload a new video and you're re-infringing, right, there's redetection, fine. But the manual claims, that's what these labels are doing. They're just sitting there, scrubbing through to try and find any and all. Because, to Rick's point, what was he? He's like, yesterday there's 25 new claims. If you go and claim, I don't know, 100, 500 videos on Rick Beato's channel, I bet that's some pretty good ad revenue.
They're claiming the same song after I already won the fair use 30-day appeal in 2021. Now, up until last November, I really didn't fight any videos at all. Never. So I got these Content ID claims and I just like, all right, whatever. And whoever claimed it got the money for my videos. My lawyer now, had told me 2 years ago, he's like, Rick, these are all fair use, which is why I decided to hire him because of the interviews. I play so many songs in them because I need to, as we're talking about it. The Rick Rubin video, I think I played about 13 different tracks in it. If I'm talking about the Beastie Boys and I want to ask them a question about it, I'll play the song, or the Red Hot Chili Peppers or Johnny Cash. You have to play these songs to talk about them. That's what fair use is all about.
Can I tell you, it's not just fair use, but actually with like trademark law, with using someone's logo or their name, if you are talking about them, you need to use their name and their logo. And so that de minimis fair use, again, just so happens to be fair use of someone's trademark in order to literally describe the thing that you're talking about. It's the same kind of like common sense, I would say, that has been built into the law. So it applies with copyright as well. Fair use, which is 17 USC section 107. Let's take a look at it. You guys need to be empowered with how this works so you know how to fight back. So the judge-made doctrine of fair use, the court, and well, the rest of us look at these 4 factors. And we consider in the framework of Rick, let's say, doing an interview. In that interview, he's using the song and he is referencing the song when talking about the song. So we go, well, the interview, he is educating, but it is of a commercial nature, right? It's not, let's say, a charitable nonprofit kind of thing. What's the nature of what he's using? It's music. And it does matter if something is music versus they pulled out a little section from like a science book, and so they're talking about formulas and facts. If it's expressive, it's music, it's videos, it gets more protection. How much was used, right? Is Rick sitting there and he is spinning around the room with someone and they're just dancing to the music for 3 minutes and there's zero comment, there's zero analysis? Well, that wouldn't qualify. What if Rick Beato's show was just a traditional show? He's not even on YouTube anymore. He's like Ellen, okay? So he calls out the guests, Beyonce's coming out, and they're playing the new hit Beyonce song. Is he allowed to be like, oh, that's fair use? Well, no, he has to get a license. So that's the point I'm trying to drive home. You don't get to just have this blanket, because I do reaction videos or educational videos, I should be able to use whatever I want, whenever I want. No. You have to use it properly, which is Rick's doing an interview. And if he's talking about, oh my gosh, that chorus, that guitar was so this and that, and then he plays the hook of the song so people can actually hear what it is that he is talking about, he is using only the amount necessary to make his educational point, which weighs towards fair use. And then finally, what's the effect on the potential market of the original song? So the argument's always just going to be, well, you got exposure, it's actually a good thing, it highlights, the song in a positive kind of way. AI. And there are instances, because we talk about our class action lawsuits as we have filed against AI companies for taking independent music creators' songs without authorization. What we're arguing, we're like, well, the AI companies are saying it's fair use. For factor number 4, we're saying they took music to create competing music. That diminishes, that destroys the value of the marketplace that the original songs are in, because now we have exact look-alike music. So that's just one example.
When I traveled to Italy to interview Rick, I pay for the airfare over there. I pay for the hotels, pay for the car that I had to rent to get down to his place, my camera crew, everything. I do it on any of the interviews that I travel on. I don't pay the people that I'm interviewing, but I pay the guys here to edit the videos and help me with all this stuff, plus all the costs associated with it. That's the reason that I decided to fight. So I spoke to Ted Gioia earlier. Ted has been on my channel a couple of times, and he wrote on his Substack yesterday about the Universal situation that I'm having. And Ted asked me, he said, do you think Universal is out to get you? And I said, no, I think that they just go after channels that have a lot of subscribers and get a lot of views. And that's the easiest way for them to make money on things. And so they're coming after me and other big channels. So after telling Ted I didn't think that they were going after me specifically, then I thought, well, maybe they are. I've had a lot of people ask me, Rick, why don't you file a harassment suit against UMG? Why don't you file a class action lawsuit? And I'm 63 years old. I had open heart surgery a year ago. I mean, I hope to live to be 100. But I don't want to spend years doing this. I just want to come on YouTube and make my videos about music. That's it. This is for other people to fight. I make the videos for the other creators on this platform that don't have the viewership that I have and don't have the resources that I have to fight this stuff. I'm making it for them. I'm trying to make people aware of these huge companies like UMG going after YouTubers and scam them out of money.
I appreciate that Rick shared that, and I find him just so endearing in that there absolutely is a path forward to get entrenched in a lengthy legal battle, possibly even a class action lawsuit, and that does take an incredible amount of energy. Whether he's protecting his peace, whether he just wants to do the good work that he's been doing on his YouTube channel, and he wants to just not be harassed by major record labels, he's using his voice, he is doing something. He doesn't have to do all the things, there are other people to do all the things, but thus far he's been one of the loudest voices to be able to just bring attention to this, which is definitely something. And also, at the end of the day, never say never.
It's funny when I see people post clips of my video and react to it and talk about it. I seem like I'm as my daughter Lennon says, a rage baiter.
No, I thought he was gonna say he's gonna need to file claims on all of our reaction videos reacting to him.
And I was like, what are you talking about, rage baiter? And then I see that, I was like, okay, maybe Lennon's right. I just get, I'm Sicilian, what can I say? I just get like that, and I can't help myself. So, but I'm being calm in this video. This is what's going on. It's continuing to happen. But, frankly, my position is that I hope other people fight it.
Being a practicing lawyer for over 11 years, I can say that some people, it's just a matter of how backed into a corner that they got. Because, for example, if Universal was to get Rick's channel deleted because they were filing these fake claims, and that destroys everything that he has built for many years. Straw and camel's back, you get my drift. All right, now I promised for fair use and filing your counter notification if you have to get to that stage 2, which is you are about to file a counter DMCA notification, and they say you, under penalty of perjury, promise that this is all true. They're gonna sue you. You could even still get a strike on your channel. It's scary, but as we've heard many YouTubers say, you gotta fight the fight when it's time. Take a screenshot. You're gonna be changing all the stuff that is in red, but the rest of it stays the same. And in your counter for notification, you're going to say Universal has improperly filed a claim. And so if it wasn't Content ID, if they've manually filed it, you can change that. But anyway, they filed a claim, and this qualifies as fair use. It cites 2 various cases, but you say my channel, put your channel name, and then reference what is the title of the video, what is the length of the video, but it goes through and just says I only used the minimal amount necessary. This was for commentary, criticism, education, pursuant to section 107, the factors of fair use weigh towards good faith. And then here's the reality. If you file a counter notification, the record label has to sue you in a court of law. And so what I've been hearing other YouTubers say is they go, it's a game of chicken. And the ones that have done this now, and they're so used to these claims, they go, I literally am not scared. Please sue me. That may or may not be where you're at, but that's why I'm doing these videos, so just try to bring awareness, help to bring education. If you found this helpful, don't forget to subscribe. I'm Miss Crystal. I'll see you on the next one.